Hi everyone, am I audible? Waiting for you all to reply on the comment box. I have opened the chat and I can see few people joining. I'm waiting for a minute more to join other people and then we'll continue with the session. Okay, so let's begin with the quiz today. How are you guys? Start commenting on the chat box. I need everyone to respond. Hello everyone. A very good evening. I can see few people watching the video. Please start commenting on the chat box. Till the time I share my screen. Good evening, Pritika. Good evening, everyone. Good evening, Dipankar. Very good to see you joining the sessions and enjoying the sessions. I am setting up the good evening, Medha. I'm setting up the whole thing and then we'll immediately begin the. I think the screen is visible. Is it? Is my screen visible, guys? Yes. Okay. Hi, Akash. Hi, Pratika. Okay. Yeah. Yes. So let's begin with the quiz. I know there's been a feeling of disappointment after yesterday's match, but we do not have to lose the battle. We have to continue with our preparation. So let's begin with the first half. And those who are new, let me tell you that today's quiz is going to be on the first part of Indian Penal Code, that is till chapter 15, and that is till before the offenses against human body. That will be I'll be covering the last section as section 298. Okay. So, how many of you have prepared the first chapter of IPC? Come on, start commenting. How many of you have read IPC before so that I can also enjoy the questions with you? Nobody? Nobody? Okay, so let's check your preparation then. The very first question on your screen now. If actus non facitrium nisi mensitria is a cardinal principle of criminal law, then which one of the following statements correctly reflects the above principle? Mens rea is an essential element of a crime, and there can't be crime without mens rea. Criminal liability under Indian law always implies mens rea. Actus reus is not always necessary to constitute a crime. To constitute a crime, there must be actus reus and mens rea. And the time is running. Okay, everyone is answering option number 4. Let me check it. I'm giving some more time for all of you to answer. Hi Hardeep. Hi Aka. Hi Seema. Okay, so the correct answer is yes, option number 4. This is one of the very landmark maxim. Some of the maxims, please note down while I am conducting the sessions, and always make a separate, separate column for for maxims so far as IPC and the other major subjects like contracts are concerned. Let's move ahead with the next question. The principle of criminal liability, actus non facitrium nisi mensitria, was developed and adopted by the equity courts, the Indian courts, the common law courts, none of these. Come on. Just apply some basic logic and answer the question. Okay, Pratika is saying the equity courts. Hardeep is saying common law courts. Monica is saying common law courts. Yes, it is developed by the common law courts and not the equity courts. It was asked in Haryana judiciary and Punjab judiciary in some years. No problem, Pritika. Do not, if you do not have any idea, in Delhi judiciary, if you are particularly going for DJS, please do not mark the answer if you have confusion in all the 4 options. Most of the people would have been confused between equity courts and the common law courts. Obviously, this is not an Indian maxim, so it cannot be developed by the Indian courts. Equity courts and the common law courts, the maxims were always there and developed. All the maxims mostly were always developed by the common law code, so always remember this for your future. When a person is said to gain wrongfully under the Indian Penal Code 1860, it means when such persons retains wrongfully as well as when such person acquires wrongfully, when such person retains wrongfully kept out of any property as well as when such person is wrongfully deprived of property, when such persons retains wrongfully but has acquired correctly, when such persons retains wrongfully kept out of any property as well as when such person is correctly deprived of property. Come on, guys. Please answer the question. What is meant by gained wrongfully? Nobody? Okay, Medha answered, Shaktija answered. Hi, Shaktija. Welcome in the live chat. Monica, welcome. Akash, Adeep, Lohat, Seema Arora, welcome. Welcome, Lohat. Welcome, Monica. Let's see the answer. Everyone answered one. Yes, it is under section 23. Please read the whole definitions starting from, I think, section very from 6, 7, 8, and ranging towards 40s. So please read them very carefully. The larger amount of prelims questions are framed from these particular sections. The definition clause. Moving ahead, the definition clause will be arranged because the IPC is amended now. So this will not be a problem for the future aspirants and after an year. But for now, we have to cope up with the messed up definitions which were already a part of IPC. Hi, Pratibha. Okay. So let's move ahead with the next question. Which among the following can be said as an element of defraud? Deceit, injury to the person deceived, both one and two, neither one nor two. This is very easy, guys. Also, mention in the comment box which section defines fraudulently. Because this is not one of the questions, that is why I am asking. Which section defines fraudulently in IPC 1860? Okay, difference of opinion here. Yes, it is 25, but what is the correct answer here? Monica said 1, Pritika said 3, Shaktija said 3, Aniqua said 3. Hi, Aniqua. Let's check the correct answer. Yes, it is 3. Both to deceit and to the injury to the person deceived and not or are necessary to constitute fraudulently, like to do something with the intention of doing it fraudulently. Um, this is under section 25. Yes. Let's move ahead with the next question. Which amongst the following maxim is related to mens rea? Otre fois acquit and otre fois convict. Actus non facit trium nisi mensit rea. Nulla poena sine lige, nullum crimen sine lige. Both 2 and 3. Also in the comment box, tell me which. Okay, let me just first you tell me the answer, then I'll ask the second question from this question. Yes, everyone is answering it very correctly. The correct answer is option number 2, actus non facit trium nisi mensit rea. It is very evident from, mensit rea. If anyone would not have known the answer, they would have also been able to answer it correctly. Tell me which is the relevant section from CRPC for option number 1. Autrophore is acquit and autrophore is convict. Which is the relevant section from CRPC for option number 1? Yes, it is 300. Yes. It is a kind of double jeopardy section. Yes. Nobody can be acquitted twice and nobody can be convicted twice. Okay. Perfect. Let's move ahead. Then, in some cases, a crime is constituted even though the act is not done with the guilty intention. These are the cases of vicarious liability, liability of state, strict liability, or joint liability. Come on, guys. Yes, Article 20. Okay, everyone is saying option number 3. Let's check the correct answer. Yes, it is a strict liability. There's no exception to strict liability. So that is the reason, even without a guilty intention, even without a wrongful intention, you will be liable for the strict liability. Which of the following provisions of IPC is associated with vicarious liability? 34, 154, 149, both 2 and 3. Come on, guys. Okay. Okay. Vicarious liability, not constructive liability. Okay. You can correct the answers if you want. Yes, Monica and Medha are. Medha, do not do this with yourself. You answered it correctly. Please do not make the mistakes in the second reading. The correct answer is both 2 and 3. Vicarious liability, guys, not constructive liability. Section 34 is constructive liability, 154 and 149 is vicarious liability. There's a thin line of difference between vicarious liability and constructive liability. Okay, so the correct answer is here not option 1 but option 4, both 2 and 3. Got it? Please read 149 and 154. Whatever the difference is between 34 and 149, the actual difference is there between vicarious and the constructive liability. I hope you guys know the difference between vicarious and the constructive liability. Okay, Cui facit per alium per se means an act done by me against my will is not my act at all. He who acts through another does not necessarily does the act himself. He who acts through another does the act himself. The act must assist intention. This is why I did not mention the difference between vicarious liability and the constructive liability because this was the maxim in the next question. Okay. Okay. Let's check the answer then. Yes, it is option number 3, not 1. It is a maxim from vicarious liability only. He who acts through another does the act himself. Yes, correct, Monica. Correct, Pratibha. Very good. Let's move ahead with the next question. Cui facit per alium facit per se is the essence of one of the following principles of criminal liability: joint criminal liability, vicarious liability, corporate criminal liability, strict liability. Come on, guys. Yes, it is option number 2. I did not give more time because I just mentioned it before. It is an example of vicarious liability. It is the maxim for vicarious liability. Which of the following does not form a part of actus reus? Thought of conduct, result of conduct, circumstances as are specified by law, or the conduct itself. This is a little tricky one. Come on, guys. Very good. Very, very good. Everyone. Medha, Pritika, Monica, Seema, very good. Hardeep, very good. Yes, it is the thought of conduct. Obviously, why would you include thought of conduct in the actus reus? Otherwise, the result of the conduct would be included. The circumstances as are specified by law will be included and the conduct itself. Very good, Lohat. Let's move ahead. The Supreme Court in 2018 observed that every attempt should be made by all courts to not to disclose the identity of the victim in terms of section 228A of IPC in the case of Lalit Yadav versus State of Chhattisgarh, Dev Singh versus State of Punjab, Ratan Lal versus State of Madhya Pradesh, Sunil Kumar versus State of Bihar. I also need the amendment year of 228A in the comment box. Come on, guys. Okay, difference of opinion here. I also need the amendment year of 228A. Okay, 3 people answered and 4 people answered and 4 of them answered differently. I'm giving you some more time. Do not open the bare acts. Just figure out the amendment year also. It is not okay. It is not a very recent year, but it can be asked. Yes, it is Lalit Yadav. versus State of Chhattisgarh. Very good, Hardeep. Very good, Pritika. And the Section 228A was added by the amendment of 1983. Okay, in the year of 1983. The maximum period of solitary confinement provided under Section 73 of IPC is 1 month, 1 month, 2 months, 3 months, 6 months. Maximum period of solitary confinement. Come on, guys. Is it Hardeep? Please check the Bihara. Okay, Shaktija, Seema, everyone has answered correctly. It is 3 months, not 1 month. Maximum period of, not in one interval, but altogether it is 3 months. Yes. All of you are answering it correctly. 6 months? No, Hardeep, it is 3 months. Which of the following statements is incorrect? Okay. To attract the offence under Section 149 IPC, it must be shown that the accused person had done the incriminating act to accomplish the unlawful common object of the unlawful assembly. To attract the offence under Section 149 IPC, it must be shown that the accused person shared the knowledge amongst themselves that the act likely to be committed in the prosecution of the unlawful common object. To attract the offence under 149 IPC, some overt act on the part of the member of the unlawful assembly is necessary to render him liable under Section 149 IPC. None of the above. Which of the statements is incorrect? I'm giving you 5 seconds to read and identify. Okay. Yes, it is option number three. No overt act is necessary under section 149, but it is necessary under section 34. So always remember that overt act means kuch thoda sa expressively to do something. 149 is itself without any overt act punishable. Yes. A, for the sake of B, his insane son gives consent for an open heart surgery, which the surgeon informs is essential to save B's life, knowing that the operation will likely to cause the death of B, but not intending so. A falls within the general exception provided in section 86, 87, 88, or 89. Very important question. Very, very important question. Come on, guys. Waiting for the answers. Lohat answered it 4. Lakshata, hi Lakshata, answered it 89. Yes, it is 89. Act done in good faith for the benefit of child or insane person by consent of guardian. Yes, it is option number 4 and not 88, 87, 86. So chalo, it cannot be the case. Not 88 and 87. Okay. Which of the following is an offense under the IPC? Keeping an offense for the purpose of drawing any lottery, not being a state lottery, receiving profits from a business which the person knows it for making obscene books to be sold, selling an obscene object to a person aged 19 years, all of the above. I need sections for all the three options as well, and the answer here. Very easy question, but I need sections for all the three options also. Yes. It is option number 4. Okay, I am not going to reveal the sections. Please mention the relevant sections of option number 4, 1, 2, and 3. एक झलक तो आपने देख ही ली है options की, but I still want everyone to reply with the correct sections. For keeping a lottery, for receiving profits from a business, for obscene books basically, and selling an obscene book to a person aged 19 years. Come on, guys. Till the time I'll move ahead with the next question. I'm waiting for the reply. A commits theft on the property in B's possession, and while committing this theft, he has a loaded pistol under his garment, having provided this pistol for the purpose of hurting B in was B should resist. A has committed the offense under 392, 382, 397, or 379. Yes, 293, one of the sections is. So the correct answer is 292, 293, and 294. A is for keeping the lottery. 293 and 292 are for receiving profits for a business and selling an obscene object to a person aged 19 years. Yes, correct, Lakshita. Correct, Shaktija. Please answer this question. A has committed an offense under, he has made preparation to hurt B, and B has resisted. No offense was committed, but A has committed theft. So, which is the relevant section here? 392, 382, 397, or 379? Come on, guys. Is it 4? Option number 4. Okay, Monica. Okay, Lohat. Pratibha is confused between 1 and 2. It is section 382, theft after making preparation for causing death, hurt, or restraint in order to commit the theft. So 382 stands very important when it comes to theft after 378 and 379. Even if you forget all the aggravated forms of theft, but remember, always remember section 382. Let's move ahead. Stolen property under Section 410 of the IPC includes property which has been criminally misappropriated, property in respect of which criminal breach of trust has been committed, property the possession whereof has been transferred by robbery, or all of the above. Come on. Okay. Only Pritika was able to answer. Shaktija has also answered. Yes, it is option number 4. Section 410 includes all the three options and it defines stolen property. Yes, correct, Medha. Let's move ahead. Good faith, defined under Section 52 of the Indian Penal Code, means an actual belief that the act done is not contrary to any law enforced, an act done honestly, in fact, an act done under the bona fide belief, an act done with due care and attention. Correct. This is an act done under with due care and attention. Okay. Let's move ahead with the next question then. Yes, correct. It is option number 4. On which of the following maxim is based on section 2 of the IPC? Nullam tempus occurrit regiae, audi alterum partem, mens rea, or actus reus? Section 2. Yes. Yes, it is option number 1. Let's understand what do you mean by nullum tempus occurrit regiae. Here, the other party, lapse of time does not bar the right of the crown. Lapse of time bars the right of the crown. Lapse of time bars the right of the person. Come on, guys. Come on. Lapse of time does not bar the right of the crown. Yes, this maxim means lapse of time does not bar the right of the crown, and this is the reason why it was based on section number 2 of the IPC. Okay, clear? Let's move ahead then. A. The landlord, knowing of the commission of a murder within the limits of his estate, willfully misinforms the magistrate of the district that the death has occurred of an asthma attack, followed with an attack of epilepsy. In such a situation, A is liable for no offense, liable for the offense under 177 IPC or 193 or 196. Come on, guys, identify the offense and let me know. Is it 177? Let's check. Yes, it is 177 because he has misinformed the magistrate, and that is the reason why he is liable under 177, which is furnishing false information. Okay? Yes, it is 177. Let's move ahead with the next question. Offense committed pursuant to a conspiracy under 120B of IPC. Every offense committed pursuant to conspiracy is non-participant conspirators can be guilty of offense or offenses committed by other conspirators. Constructive liability falls on all conspirators in view of the conspiracy under section 120B of IPC. Those who committed offences pursuant to conspiracy indulging in various events, acts will be individually liable for those offences in addition to liability for criminal conspiracy, only liable for the separate and distinct offence to which individual offender are liable for individual punishment. Welcome, Ravi. Welcome to the video. Let's wait for the correct answer. I'm not changing the screen for you to read. Okay, Hardeep has answered 3. Everyone is answering 2. Let's move ahead. Yes, the correct answer is option number 2. Constructive liability falls on all the conspirators in view of the conspiracy under. It is a constructive liability, obviously, under section 120A, and other options are not correct. Okay. Yes, it is common with section 34 also. A instigates B, a child below 7 years of age, to set fire to a dwelling house. A is not guilty as there is no question of abatement of child. A is guilty of abating B to set fire. Can't say none of these. Guys, ऐसे questions पे ना automatically एक option तो remove ही हो जाता है. And you know which option I'm talking about. So you have to choose between 3 options. And mostly in DJS, like I'm not telling you the correct answer here, but mostly in DJS and the states which twists questions like Haryana, DJS, Uttarakhand, and MP also these days. The correct answer in most of these illustration based questions, particularly with IPC, is none of these. But here the correct answer is option number 2. Yes, A is guilty of abating B to set fire. Even if the person is below, it is mentioned in the explanation of 108 that even if the person is unsound or minor or not capable to, understand the things, even if that is the case, but the person who is abating will be liable for abatement. Yes, section 108. Yes. If an offender has been sentenced to imprisonment not exceeding 6 months, the solitary confinement shall not exceed 1 month, shall not exceed 2 months, shall not exceed 45 days, shall not exceed 15 days. Come on, guys, this is very easy. Directly from section number. Which section? Tell me. 72 or 73? Correct. Everyone is correct. Medha, Pratibha, Hardeep, please read Shaktija and Monica and Ravi. Again, the section it is option number 1. Not exceeding. Is this not visible on the screen? Not exceeding 6 months. Not exceeding 6 months. So then it is, yes, it is 73. Not exceeding 6 months, then it will be 1 month. Okay, a hangman who hangs the prisoner pursuant to the order of the court is exempted from criminal liability by the virtue of 78, 79, 76, or 77. And always remember the correct answer here is known as the hangman section. Yes. It is option number one. Section 78 is the correct answer, and it is also known as the hangman section. For a defense of intoxication to escape criminal liability, the intoxication administered against his will or knowledge shall not be self-administered, can be self-administered, all of the above. Yes, correct, Ravi. Come on, guys. For the defense of intoxication to escape the criminal liability, to escape the criminal liability. Yes, all of you are correct. Correct option is option number one. And the relevant sections are 85 and 86. But for that, this particular thing, the correct section is 85. And it was a previous year question from DJS 2006. A boy over 11 years but below 12 years of age picked up the knife and proceeded towards the victim with threatening gestures, saying that he could cut him into pieces and actually stab him to death. The boy will be guilty because he had attained maturity of understanding to judge the nature and consequence of his conduct of mind, and the act concurred in this case. The boy will not be guilty of murder. The boy will not be guilty of murder as he had not attained sufficient maturity of understanding to judge the nature and consequence of his conduct. The boy will not be guilty of, as child of age of 12 years cannot be guilty of an offense. Come on, guys. Everyone is correct here. Yes. The boy will be guilty because under section 83 it is provided that a person above 7 years and under 12 years of age, if he or she will be able, has attained maturity, and it is on the discretion of the court to judge the nature and the consequence and understand the circumstances of the case, and if the circumstances are such that the person has understood the liability, then he will be liable under this. Okay. Yes. Five persons conspire to loot a bank. Two of them, M and N, stay on in car with engine running on and at entrance of the bank. Three of them, X, Y, and Z, enter the bank. X shoots the cashier and Y and Z loot the cash. Police suddenly reaches the bank and apprehend Y and Z, but X escapes on seeing the police enter the bank. M and N also run away in the car. Later on, all the five are arrested and charged with the offense of dacoity, looting, and murder. M and N plead that they are not guilty of any of the offense, certainly not murder and looting, as they did not participate in any of these offenses. Should their plea avail, MNN are at best liable of abating robbery but not of committing it. Since looting of the bank was committed in furtherance of the common intention of all five, MNN are equally liable for looting and murder along with X, Y, and Z. Okay, people have started answering. Thus, their defense will not prevail. MNN has no complicity in any of the offenses. MNN are not liable for committing robbery and murder. Very easy but very lengthy, so read the questions quickly because DJs might give you heart attacks when it comes to time. It is a race against time. Also, when it comes to prelims, yes, it is too. Section 34 is the correct section here. So the person who are committing an offense in furtherance of a common intention are also liable in the same way. Yes. In which of the following cases, the offense of abatement is committed? X and Y attend reception of bride who was only of 13 years. M officiates as priest or pandit in marriage of a girl aged 15 years and boy aged 12 years. Ex widow prepares herself for sati and proceeds towards the pyre of her husband. X, Y, and Z follow her by shouting repeated Ram Ram. Only in B and C. Section 34 IPC provides no, this is the invalid section. Only in B and C. Only 2 and 3. Okay. Let's check. The correct answer is option number 3 here. Yes, both of the situations are such where the abatement of an offense is committed by the other persons who were standing and shouting Ram and Ram, and who were the priests and whoever attended the reception. Yes. Let's move ahead with the next question. Offense committed pursuant to conspiracy under Section 120B of IPC. Every offense committed pursuant to conspiracy is non participant conspirators can be guilty of offense or offenses committed by other conspirators. Constructive liability falls on conspirators in view of the conspiracy under Section 120B. Those who answered it already will not answer. Only those who have joined new, for example, Ravi and others, yes, it is option number two. Correct. Constructive liability is there for section 30, 120A and 34. Whoever being legally bound by oath to state the truth or being bound by law to make a declaration upon any subject matter is said to give false evidence when he makes a statement which is false, he makes a statement which he believes to be false, he makes a statement which it does not believes to be true. All of the above. Come on, guys. Yes. All of you are correct. It is option number four. The correct answer is option number four. All these things are very correctly stated. Let's move ahead with the next question then. Section 95 of IPC provides that nothing is an offense which causes slight harm. Law does not take cognizance of trifles. Which section of the IPC codifies in the field of criminal law the maxim de minimis non curate lex? This was a question in DJS itself giving the answer. Triple, yes, it is section 3. Yes, told you that this was one of the questions in DJS. When an act is abated and a different act is done by the person instigated, the abater is liable for the act done in the same manner and to the same extent as if he had directly abated it, provided the act done was a probable consequence of the abatement, irrespective of being committed under the influence of instigation. The act was done with the aid or in pursuance of the conspiracy which constituted the abatement. The abater had reasonable ground to believe that a different act may be committed, or all of the above. Yes, trifle. Correct, Ravi. Let's check the correct answer here. Is it one? Hardeep is saying four. It is two, guys. The act was done with the aid or in pursuance of the conspiracy which constituted the abatement. Please check out the sections, section 111, and then let me know the correct answer. Okay? Let's move ahead. Nothing is an offense if it is done by a person who is a boy of 6 years having sufficient maturity to understand the nature and consequence of his conduct. Girl below 12 years having sufficient maturity to understand the nature or consequence of a conduct. A man aged 100 years, all of the above. Who will not be liable for any of the offense? Yes. Yes, it is option number one and very clearly given under 82. A person below 7 years will not be liable in any of the case. Can someone tell me the relevant um, section? Okay, I told you. Can someone tell me the relevant maxim here? A going to pilgrimage and trust 10 gold coins to B for keeping in safe custody till his return. B sells those gold coins to a goldsmith. B is guilty of theft of gold coins. B is guilty of criminal breach of trust. Both A and B, none of the above. Yes, it is Dolly in Capax. C. All of you are answering option number two. Yes, the correct answer is option number two, and it is under CBT. Can someone tell me the correct relevant section for criminal breach of trust? I know it is a second part of IPC, but let's revise the second part also. Let me know the correct section for criminal breach of trust in the comment box. A police officer is directed by the court to arrest B. He arrests C after reasonable inquiry, believing C to be B. A has committed the offense of wrongful confinement as he has arrested C instead of B. A has committed the offense of wrongful confinement as he was negligent in arresting C. A has committed no offense because he arrested C in good faith, believing himself to be bound by law to do so. None of the above. Yes, correct, Pritika. It is 405. Come on, guys. This is an illustration based question, but a really easy one. Yes, it is option number 376. Act done by a person bound or by mistake of fact, believing himself bound by law to do so. And it is an illustration also, illustration number B. Correct. A, B, and C plan to enter into a jewelry shop and commit theft at the shop. They collect the. Just a second, guys. Okay, let's continue. A, B, and C plan to enter into a jewelry shop and commit theft at the shop. They collect the implements of housebreaking and go to the jewelry shop to execute their plan. On reaching there, they find police patrol vans stationed outside the shop and hence return. Their act amounts to attempt to commit housebreaking and theft, criminal conspiracy, both A and B, none of the above. Come on, guys. Am I audible? Yes, people have started answering. It is just criminal conspiracy, guys. No attempt was made. See, there's a difference between, let me just answer the question, which offense is punishable at the stage of preparation? Ek to ye. And then there's a difference, thin line difference between a stage difference between preparation and attempt. So this is just at the stage of preparation, not the attempt. They did not attempt it. They did not go beyond the stage of preparation. Nobody went into the shop, nobody shouted, nobody showed the weapons of housebreaking, nothing. So this was just criminal conspiracy, which, yes, correct, Shaktija, correct. Only Shaktija was able to answer it correctly. So, what all offenses are punishable in the stage of preparation? Can somebody tell me? Let me just tell you one offense which is directly mentioned in the Bear Act. It is dacoity. Which other offense is punishable under criminal conspiracy? Yes, but what is which offense? There's one more offense which is punishable in the stage of preparation. It is counterfeiting coins, guys. So counterfeiting coins and dacoity are the only two offenses I can remember now. Yes, those two offenses are there, which are punishable at the stage of preparation. A police officer directed by the court to arrest B. He arrests C after reasonable inquiry, believing C to be C. Okay, this is Section 76 of IPC provides that nothing is an offense which is done by a person who is or who, by reason of mistake of law and good faith, believes himself to be bound by a law to do it. Mistake of fact and good faith believes himself to be bound by law to do it. Mistake of fact believes himself to be bound by morals to do it. All of these. Dacoity is, I think, 399. If I'm remembering it right, it is 399. Yes, making preparation to commit dacoity. Okay. Yes, it is option number 2 and very clearly stated in section 76. Right of private defense extends to defense of body only, defense of property only, defense of both body and property cannot say. See, again, one option is automatically eliminated, and you know the answer here. Correct, Medha. Correct. Hardeep, Pritika, Shaktija, Pratibha, Monica, everyone is answering the thing correct. Yes, it is option number three. I think my camera is not visible. I don't know why. Is it is visible now? Okay. Yes, it is under Section 97, which says that the right of private defense is extended to body also and property also. The right of private defense of the body can extend to causing death in case of apprehension of grievous hurt and death, in case of apprehension of being raped, in case of assault with the intention of kidnapping or abducting, all of these. Body, not property, body. Tell me the relevant section also here. In which cases right of, I know these sections will be, you will have to wash away these sections after an year because the section numbers will be jumbled up. But yes, अभी तो हमें इसी से काम चलाना है. तो मुझे बताओ which is the relevant section here for right of private defense extending to cause death of the body. Section 100, yes. The correct answer is option number 4, and this was asked in DJ's 2015. Yes, correct. All these three cases and all the other four cases, like there are seven provisions you guys have to remember for body and for property also. You will have to remember all the clauses because these two sections are the most important sections. For property, I guess there are four clauses. Yes, there are four clauses, so you'll have to remember 7 plus 4 is 11 clauses. Always on your tips for prelims and mains. 100 and 103, both are very important. A is working in a field with a spade. The iron head of the spade flies off and hits a person who dies. A cannot be prosecuted for any offense. A can be accused of murder. A can be accused of attempt to murder. A's act is not an offense if it is found that he had taken proper caution. See, अब ऐसे questions में choose the most appropriate one. There can be two options correct. I know you can give me, like I was also when in the preparation stage I was also used to give hundreds of logic ki nahi ye kyun nahi ho sakta and file objections, but no use. This has to be dealt with the most appropriate answer. Yes, it is option number 4. Whenever there is an option accident में हमेशा remember proper care and caution. जहाँ mention हो गया तो offense defense मिल गया, offense नहीं हुआ. And when there is no mention of care and caution, the defense is not given. Yes, option number 4. Very good. The maxim de minimis non curate lex is the foundation of which of the general exception under chapter 4 of IPC? Act causing slight harm, act of child under 7 years of age, act of child above 7 and 12 of immature understanding, accident in doing a lawful act. ये हो चुका है guys. This is you have already been able to answer de minimis non curate lex. Even someone, I think Ravi answered it with the meaning of the maxim also. Yes, it is option number 1. Correct. It is section 95, act causing slight harm, trifles. A who is abducted by B is forced by the threat of instant death by B, who is heavily armed to use A skills as a smith to force upon the door of a house in order to enable B to commit robbery. A has committed housebreaking, house trespass, robbery, no offense. Is it housebreaking? It is no offense, guys. Yes, correct, Monica. Very good. It is no offense. See, the point is ki I am asking about A. A has abducted A, who was abducted by B, is forced by the threat of instant death by B, who is heavily armed. Which section is this, guys? Which section is this? It is one of the general exceptions and not an housebreaking. Why would I ask a housebreaking illustration here? Because we are dealing with part one. It is no offense. Generally, DJs, MP, and Uttarakhand, Haryana, Himachal even ask such questions. Yes, it is 94. Act to which a person is compelled by threat. So this was a clear threat, and that is why A has committed no offense. He was abducted. A, who is a 19 years of age, instigates his sister, who is 6 years of age, to pick the pocket of co-passenger. As soon as B slips the purse of the co-passenger in her school bag, she is caught. However, when the purse is opened, it is found to be empty. In this case, which of the following statements is correct? A and B have committed no offense. A has committed no offense while B has committed theft. A has committed an offense and B has abated the same. B does not commit any offense and A is guilty of abatement. Yes, it is 94, Shaktija. Correct. But you read the. Okay, you answered four. No, you answered one. Pritika also answered one. Medha also answered one. Please, guys, read the general exceptions wala part again today. Okay, everyone is answering four. Yes, it is four. B does not commit any offense since she was below 7 years, and A is guilty of abatement. Even if, see, this is the way they twist you. The purse is empty. There was no point of mentioning this. अगर empty हो, पैसे हो, कुछ भी ना हो, that does not make a difference. The person is liable for abatement, and B would have been liable of under section 511 for committing attempt to theft because she was caught, so she did not commit the theft if she would have been above 7 years of age. अब वो that depends upon court 7 to 12 वाला provision apply हो जाएगा, but yes. Are we on the same page, guys? We are halfway through. We have done 50 questions almost. Are we on the same page? How's the Josh? Comment hi on the chat box. I'm giving you a 10 seconds break. What's up? How's the preparation going? IPC, did you cope up with CRPC yesterday? Were you guys able to revise the provisions I told you to revise yesterday or not? Tell me. Tell me, come on. Nobody is replying. Even, am I even audible? Hello? आवाज आ रही है? Tell me, guys. Am I audible? कि कितना चिल्लाओगे बता दो. Yes. How is the preparation going? Hi. Okay. Okay. So come on. Let's move ahead with the next question then. Yes. Yes. Okay. I hope CRPC was not a very heavy thing for you guys yesterday. IPC can be very heavy. I accept it. Please cope up for the first few days and then we'll have minors. The minors thode easy ho jayenge. Even from tomorrow, like tomorrow we'll have other part of IPC and from day after tomorrow you'll have contract and all those subjects thode se minor ho jayenge, so you'll be comfortable then. Let's move ahead. A government servant removed a file from a colleague's office of his house, made it available to an outsider, and then returned it back to the office the same day in the evening. A is guilty of which of the following offense? Criminal misappropriation of property, theft, criminal breach of trust, none of the above. I understand it, Shaktija. My eyes are even paining. See, I've been making these slides, arranging the questions, preparing, doing other work. So we are all on the same page. Yes, it is option number one. No, it is option number two. Hardeep answered it option number one. Option number three, I thought theft is at option number one. Okay, nobody is answering theft. Possession से remove कर दिया guys. This is not entrustment. This cannot be criminal misappropriation. Oh sorry, हाँ CBT तो हो ही नहीं सकता. There is no entrustment. A government servant removed a file. See, again to twist you guys, there's a word attached government servant. Removed a file from a colleague's office of his house, made it available to an outsider, and then returned it back to the office the same day in the evening. He did not use it, right? So there is no misappropriation, there is theft. They cannot be criminal breach of trust. This is simple removing of a movable property out of the possession of somebody dishonestly. All the essential ingredients of thefts are getting fulfilled. It is theft. Acha, I have included this illustration. Okay, let's move ahead then. When A dies as a result of act of violence by person B, person C not present at the scene of crime can be prosecuted under the IPC under section 120A to 120B of IPC, 141 to 149 of IPC for act done in furtherance of common intention under section 34 for vicarious liability as C was aware of the offence was likely to be committed by B. Come on. Person C. Confused हो गए? Okay, so the correct answer is option number one here. Without the proof of anything extra, we cannot prosecute. Like we cannot prove common intention. Vicarious liability is also cannot be proved. Criminal conspiracy could have been done even if the person is not present there. So that is why it is option number one. Only Monica was able to answer. Very good, Monica. You are on fire. The difference between section 30, that is the reason I did not mention difference there. Difference between section 34 and 149 of IPC is whereas in section 34 there must be at least 5 persons, section 149 requires only 2 persons. Section 149 is only a rule of evidence, whereas 34 creates a specific offense. Section 34 requires active participation in action, whereas section 149 requires mere passive membership of the unlawful assembly. Both 2 and 3. अगर ये फिगर आउट कर लिया कि विच इज रूल ऑफ एविडेंस यू विल बी एबल टू आंसर इट जस्ट अ वेरी सिंपल थिंग yes all thanks to Mahinder sir he is also always on fire he teaches very well yes it is option number 3 guys why option number 4 you are all you Hardeep and Lohat thinks it is option number 4. 34 is a rule of evidence and 149 creates a specific offense. 34 is a rule of evidence, guys. And 34 requires active participation. This is the correct. 3 is correct. Option number 2 is wrong. That is why I specifically mentioned if you know, yes. Correct, Shaktija. 34 is a rule of evidence and 149 is not a rule, just a rule of evidence. A is carried off by a tiger. Z fires at the tiger in good faith, intending to rescue A, knowing it to be likely that the shot may kill A. The shot fired by Z gives A a mortal wound. Z has committed no offense, culpable homicide not amounting to murder, offense of causing death by negligence. Come on, guys. Okay. Difference of opinion here. Majority is with no offense. Yes, it is no offense. Very good, Pratibha and Hardeep and Pritika. See, it is coming under section 81 without any criminal intent and to prevent basically the defense under section 81. It is coming under, and that is why it is not an offense and it is under section chapter 4. Yes, correct, Medha. Sedition is committed by exhortation to the people not to pay governmental revenues, exhortation to join a particular party, expressing disapprobation of the administrative action of the government without exciting or attempting to excite hatred, reciting seditious poem in a public meeting. Sedition. This is going to be removed after an year. This is making me, while I was arranging for the questions, every time I was remembering this, that this is going to be removed. Sedition is removed from the new act. Yes, it is option number 4. Correct, Medha? Reciting seditious poem in a public meeting will constitute sedition. Otherwise, all the things we can do, we should not do, but we can do, like we should not do at least the first option. Other things, so you can do. Okay. Yes, correct, Hardeep. This is option number 4. Which of the following statements is correct? In conspiracy, there is no distinction between principal and accessory. In conspiracy, principal and accessory are distinct. There has to be a distinction between principal and accessory in all offenses. None of these. Principal and accessory. And also tell me which is the second offense जहाँ पे principal and accessory में difference होता है. या सेकेंड ऑफेंस नहीं तो किस ऑफेंस में डिफरेंस होता है इन प्रिंसिपल एंड नेसेसरी. Come on. Okay. Yes, there's no distinction between principal and accessory. All the persons are liable with the same liability. Which is the offense which has a difference between principal and accessory? Comment on the chat box. I want to know whether you know that there is such a thing like principal and accessory in IPC, and which offense is the correct offense. A foreigner stabbed another foreigner in a foreign vessel on the high seas. Both A and B were brought to Bombay. A foreigner stabbed B, another foreigner, in a foreign vessel on the high seas. It is abatement. Yes, correct, Monica. It is abatement. Yes, no question. It is abatement. Foreign vessel on the high seas, both A and B were brought to Bombay for treatment where B died. A is also available in Bombay. Which of the following propositions is correct in respect of applicability of IPC to the trial of A? As both the deceased and the accused belong to foreign countries and the occurrence of offences has taken place on the high seas, IPC is not applicable to A and hence he cannot be prosecuted. IPC is absolutely not applicable to a foreigner and hence A cannot be tried in India. As the offences is completed in Indian territories and accused A is available in India, as IPC is available to Indians as well as foreigners, A must be tried in India. Okay. Yes, it is option number 1. See, both of them when belong to foreign countries and the occurrence of the offense is also on the high seas, IPC will not be applicable. No. Option number 1 is the correct answer here, Medha. Not 3. Option number 1. IPC will not be applicable. Please read section 234 and make a chart out of all the 3 sections. You'll be able to understand. It is a question in 2010 DJs. Let's have some true and false, guys. The publishing of the name of a rape victim who is a minor is not an offense if it is done under written authorization of the victim. True or false? Come on. Okay. Yes, it is false. 4, which is option 4, Shaktija. You meant false? Yes, it is false. To 28A is the relevant section here. Again, even if the written authorization is given, publishing of a name of a rape victim who is a minor cannot be published. Like it cannot be done. It is an offense. It will always be an offense. Under IPC, the word man denotes an infant boy as well. True or false? Man denotes an infant boy as well. Man includes an infant boy as well. Yes, it is true. Correct. Please mention the section number. Which section defines man and woman? Nothing is an offense which is done by a child under the age of 10 years, 7 years. It is female child under the age of 10 years, under the age of 9 years. Come on. Fatafat de do. These questions will make you secure marks. Yes, it is option number 2. Refer to section 82, which is under this age of 7 years. Correct. It is option number 2. The publishing of the name of a rape victim who is a minor is an offense. Okay, this is repeated. Let's move ahead. IPC does not extend to J and K. Come on, IPC does not extend to J and K. Yes, it is false now because after the Jammu and Kashmir Reorganization Act of 2019, it is also extended to Jammu and Kashmir. Kritika, why is it true? It is false. After 2019, it is false. What is the time limit prescribed under Section 2 of the IPC 1860 with which prosecution should be launched? Immediately after the offence, within 1 year of the commission of offence, within 3 years of the commission of offence, no such time limit is prescribed under Section 2. घूमना नहीं guys. Yes, it is option number 4. No such time limit is prescribed. Correct. What does extraterritorial jurisdiction in respect of IPC mean? Where a crime is committed outside the territory of India by an Indian national and such person may be tried and punished by Indian court. Where a crime within the territory of India by an Indian national and such person may be tried and punished by Indian court. Where a crime is committed within the territory of India by a person and such person may be tried and punished by Indian court. Where a crime is committed outside the territory of India by an Indian national but such person shall not be tried and punished by Indian court. Hardeep is saying 1. Shaktija is saying 4. It is 1. See, it is very well mentioned under section 4 that where a crime is committed outside the territory of India by an Indian national and such person may be tried and punished by the Indian court. This is what is meant by extraterritorial jurisdiction. It is 1. Yes, everyone is right. Whether IPC 1860 applies to an offense committed by a citizen outside India? Yes, no. If the offense is associated and has nexus with another offense committed in India, only if there is a mutual treaty between India and the country in which the offense was committed. Come on, everyone. Okay, Hardeep is saying straight away yes. Pratibha is also saying yes. It is yes, no ifs and but. Under section 3, if any person is liable by any Indian law to be tried for an offense committed beyond India shall be dealt with in according to the provisions of this particular code. Yes, correct Pratika, correct Medha. Wherein the IPC 1860 it is stated that certain laws not to be affected by this act. 4, section 5, section 6 or section 7. Come on. Is it section 5, Pratibha? Yes, it is section 5. Yes, everyone is correct. Welcome, Mikhayan Sabarwal. Welcome in the chat box. Yes, it is section number 5. Assertion and reason question. Assertion is where the sister of X was being abducted by force from her parents' house by her husband. X caused death of sister's husband in defense of the sister against an assault with intention of abducting by the force. It was held that private defense of body extends in the above circumstances to the causing of death. Reason is the word abducting in section 100 includes abduction simpliciter. Both A and R are true, and R is the correct explanation of A. Both A and R are true, but R is not the correct explanation of A. A is true, but R is false. A is false, but R is true. Is it the correct explanation, or even the reason and assertion is wrong? Okay, Monica is saying one. The person who is able to solve assertion and reason question is, according to me, great. Assertion and reason questions are most tricky. उसका कुछ भरोसा नहीं होता. Okay, Shakti is saying तो ये तो गलत ही है. Let's see, Medha and Monica are correct. See, it is very basic. Like A was obviously correct. It was held by the court that in the circumstances of causing of death, and this is abducting, and abduction includes the word simpliciter. So it is A, not three, not like it is one, not three, not two, not one. A, who is a citizen of India, commits murder in Uganda. He is arrested in Delhi. He can be tried and convicted for murder only in Uganda, only in that country of which the deceased was a citizen, in Delhi, at any place in India. Come on. In Uganda, in that country of which deceased was a citizen, in Delhi, at any place in India. At any place in India? Yes, it is at any place in India. Illustration is mentioned under section 4. Even if he is a citizen of India, he can be convicted and tried for murder at any place in India. Correct. The accused found the deceased engaged in a sexual intercourse with his 15 years old daughter. The accused assaulted the deceased on the head with a spade, which resulted in the death. The accused claimed private defense, and the prosecution claimed that the intercourse was with consent. Here, accused is entitled to right of private defense since the girl was a minor. Accused exceeded the right of private defense. Accused is not entitled to right of private defense as the intercourse was with consent. None of the above. Come on. Okay, he exceeded the ROPD. Let's see. No, he is entitled to the right of private defense. See, this is one of the illustrations which was a kind of controversial in the year which it was asked. Yes, correct, Monica. Correct, Shaktija. Can somebody tell me the reason why uh, he was given the ROPD? Which section and which clause? No, it is not two. He did not exceed the ROPD. Mention section current correct clause of section 100 here. What shall be the meaning of the term computer resource for the purpose of section 4 of IPC? 21K of the IT Act as defined in section 21J of the IT Act, as defined in section 21I of the IT Act, or 21H of the IT Act. Come on. Yes, it is option number one. It was directly from the Bear Act. Can somebody tell me the relevant section of section 100 here? Yes, it is mentioned under explanation B of the section 4 of the Act that as defined by 21K, the computer resource, the meaning of the computer resource will be same. Correct, correct. Everyone is correct. For the offense of, for the purpose of section 4 of IPC, what does the term offense include? Every act punishable under the IPC, every act committed outside India, every act committed outside India, which if committed in India would be punishable under the IPC, every act committed outside India. Yes, it is option number three and mentioned in the explanation also of section four. So this was directly taken from the section four definition of offense. It kind of defines offense. A police officer without warrant apprehends Z who has committed murder. Here, A is not guilty of the offense of wrongful confinement, for he was bound by law to apprehend Z. The case does not fall within the general exception, which provides that nothing is an offense which is done by a person who is bound by law to do it. The case falls within the general exception, which provides that nothing is an offense which is done by a person who is bound by law to do it. The case falls with general exception, which provides that nothing is an offense which is done by a person who is bound by law to not bound by law to do it. The case does not fall within the general exception, which provides that nothing is an offense which is done by a person who is bound by law to do it. Let's see. Yes, it is option number two, and it is very well mentioned in the definition in the section illustration B of section 6. The case falls within the general exception, which provides that nothing is an offense which is done by a person who is bound by law to do it. Can you tell me the relevant section here? Is it 76? The sections in the IPC which contains definitions of offences do not express that a child under 7 years of age cannot commit such offences. But the definitions are to be understood subject to the general exceptions, which provides that nothing shall be an offence which is done by a child under 7 years of age. This has been stated under illustration A of section 6, illustration B of section 6, chapter 4 of IPC or chapter 2 of IPC. Okay. No, this is mentioned under illustration A of section 6, guys. Option number one is the correct answer here. No, no. Option number one, Muskan, option number one. Welcome, Muskan. Option number one is the correct answer. Who, according to section 21 of IPC, is not a public servant? Juryman assisting the court of justice, an arbitrator who to whom any cause has been referred for decision by any court of justice, person who holds any office by virtue of which he is empowered to place or keep any person in confinement, an advocate who practices law in a court of justice. Who is not a public servant? Correct. Everyone is correct. Advocates की कोई इज्जत नहीं है. We are not a public servant. Yes, it is option number 4. Correct. Correct. Now match the following. Please see the codes yourself and I'm giving you 10 seconds. You match it. Are we receiving the answers? Yes, it is option number 3. This is directly section based question. It is option number 3. So 17 is defined, government is defined under section 17. Section 10 defines man. Section 8 defines gender. And section 14 defines servant of government. Correct. Okay. The stones and minerals which are beneath the earth when served from the earth are Immovable property, movable property, incorporeal property, both 1 and 3. अब ये मत बोलना ये आईपीसी में कहाँ से आ गया, ये आईपीसी में आ गया because it is defined in IPC. Yes, it is immovable property, and it was a case in Shivram, in the case of Shivram by Bombay Court in 1891. And which section defines movable property? Come on, guys, quickly in the comment box. Which section defines movable property in IPC? Not in TPA, in IPC. In which of the following cases Lord Somerset they also serve who stand and wait? Mehboob Shah versus Emperor, Inder Singh versus Emperor, Barendra Kumar Ghosh versus Emperor, Kedarnath versus State of Bengal. Yes, it is 22. Please tell me the relevant case law here. It is Barendra Kumar Ghosh versus Emperor. Yes. They also serve who stand and wait, and Mehboob Shah versus Emperor is the letterbox case. Kedarnath is a sedition case. So always remember these landmark cases for future. In which of the following circumstances a woman in exercise of a right of private defense of the body can cause death to the of the perpetrator? When a man demands or requests for sexual favors, when a man attempts to throw or administer acid which may reasonably cause apprehension of grievous hurt, when a man captures the image of a woman engaged in a private part, when a man follows a woman to foster personal information. Again, section 100. Yes, it is option number 2. Only in the second case, which is the newly added clause. Which amendment? Tell me the amendment year. I asked it yesterday also, 326A. Tell me the amendment year of acid attack. And this clause also in section 100. Quickly tell me the amendment year, guys. In a case where the deceased was murdered by one of the two accused with a sharp edged weapon while he was sleeping on a cot in his house, while the other accused, his brother, without taking part, stood by with a spear in his hand to overcome any outside interference, and both the accused ran away together after the murder. Section 34 cannot be applied. Section 34 can be applied because the presence of accused is away from the scene. Can't be determined, none of the above. Yes, it is 2013. Correct. 100 ka 7.3 clause. Correct. Very good, Pratibha, Medha, and Mikayan. Tell me the correct answer here, whether 34 can be applied or not. Basically, this is between option number 1 and 2, or it can be option number 4 also. Okay, let's see. Yes, it is option number 1. Even if the presence is not there, section 34 can be applied. So, yes, it is option number 31. A mentally disturbed person picks out a revolver and point towards B and attempted to fire at B. B picks a flower pot and hits A, causing grievous hurt to A. B is not liable for causing grievous hurt to A. B is not liable for causing grievous hurt but simple hurt. B has acted in private defense, therefore he is not liable. Right of private defense is not available against a mentally disturbed person. Please choose the most appropriate one. There are two options, just may confuse hoge, but please choose the most appropriate one. Pratibha has answered. Monica, Pritika, everyone is on the same page. Yes, it is option number 3. Yes, option number 1. Agar option number 3 nahi hota, to option number 1 would have been okay. Option number 2 would have been but simple hurt likha hai yahan. ठीक है. Option number 2 would have been the correct answer if not mentioned but simple hurt. Otherwise, option number 3 is the correct answer. Very good. Okay. In which year was the offense of sedition under section 124A subsequently amended after insertion? Subsequently amended after insertion, second amendment, 1948, 1898, 1955, all of the above. कब बाद में amendment हुई है sedition की? After insertion. Come on. Everyone, guys. This is a little tricky one. Without the Bear Act, you have to answer. Please answer it quickly. Yes. Hardeep is saying 3. No, it is 4. The explanation is mentioned here. Each and every word. See, it was amended in 1950. Her Majesty was added. Then in 1948, the word Majesty was removed, and then life imprisonment substituted in the year of 1955. So it is all of the above. That's all for today, guys. We have done almost 100 questions. How are you feeling? What is going on in your mind? Tell me in the comment box. You all have done very well. So far as part 1 is concerned, we'll tomorrow meet with part 2, which is going to be a very, very, very important one because offenses against body and offenses against property are included in part 2. You're welcome, Hardeep. As you have mentioned, thank you, ma'am. Welcome. Was the session good, fruitful, exciting? What were the questions? How were the questions? How was the speed? Definitely, Pratibha. Any scope of improvements? Still, you were very good, Maikyon. I think you did very well. You were able to answer some of the questions. IPC tha isliye, but I think please attend tomorrow's session also. Tomorrow's session will be the substantial portion of IPC at the same time, 7 p.m., guys. So good. Okay. थोड़ा सा territorial jurisdictions में था and general exceptions particularly. Thank you so much, ma'am. Okay, you're welcome. So let's meet tomorrow at the same time at 7 p.m. with the second part of IPC. I'll be waiting for all of you to join. Tell your friends also to join. Whoever are preparing for DJS or MP or any of the states coming up or even not coming up or even not preparing, you guys can revise your concepts. I'll be waiting for you. Thanks a lot. Thank you for the patience and thank you for answering the questions.